Welcome to Toy Business Unboxed, your gateway to the secrets of the toy industry. Here, Jason Shea, a toy entrepreneur and expert in the field.
Every product we develop is really inspired by some of the real life experience that we have with our son.
60% of all toys last year were sold on Amazon, which is incredible.
Be passionate about it because it's a road, it's a journey.
Like when you have an idea that you think is like gonna somewhat like change the world, make things better, I'd say go for it.
We'll guide you through the enchanting world of toy design, marketing, and manufacturing. Now let the unboxing begin.
Hello, welcome to another episode of Toy Business Unboxed, where we dive into the world of toy innovation and entrepreneurship. In today's episode, we're thrilled to have John, the patent professor, a leading patent attorney over 2 decades of experience who have made his mission to protect the dreamer, the inventors, and the changemaker of the world. John has dedicated his career to helping creators, especially those in the toy industry, secure patents and defend their IP or intellectual property. Whether you are just starting out or have a growing toy business, this conversation will equip you with the right knowledge and key strategy to protect your idea from copycats and knockoff. John, thank you so much for joining us on the podcast today.
Yeah, thank you, Jason. It's a pleasure to be here.
Can you tell the audience a little bit about how do you start your journey working in specialized, especially because there's so many different type of law practices? What make you want to decide on specializing like on the patents?
It's funny, my journey started years ago with taking you back in time, back when I was 12. And it started with a toy because my dream and sole ambition in life was to take a Rubik's Cube, which is cubical, and I wanted to make it round.
Really?
And create like a Rubik's sphere. So day in and day out, I would have a sketchbook under my bed, page after page of drawings and sketches of my design, and everything was going well, except one day my mom brought me to the mall, and there's a store, KB Toys. And I went to that aisle where they have the puzzles and games. Saw there on the store shelves, like crushed me. Somebody had already made a round Rubik's Cube, and they came up with a better name than round Rubik's Cube. They called it the Impossible. In my like 12-year-old mind, like they had stolen my idea. I remember being at the mall. I tried hard not to cry. I looked up at my mom, and my mom was crying. And remember, like she's the one that had seen the sketchbook and how much work I put into it day after day. She's the one that tripped over all the broken Rubik's Cubes that had a screwdriver to it and break it apart. So I grabbed her by the hand and I dragged her out of the store. The store clerks had seen plenty of parents dragging crying children out, but never
a crying mom. Oh, whoa.
So children cry when they don't get what they want, but something happens to us when we grow up. And that's the thing. We stop thinking we can get what we want, and we start dreaming small and dreaming safe. I never forgot that experience. And I always loved tinkering with things, taking things apart, figuring out how they work. And I became an engineer, and when becoming the inventor of the round Rubik's Cube didn't work, engineering was my backup. And that's when I got exposed to patent law ideas. And that's what I've done the past 25 years. And in fact, I've been a professor teaching patent law to other lawyers. That's where my law firm's name, the patent professor, actually comes from.
I see. That makes total sense. I didn't know that story. You didn't mention that in the pre-interview, but that's a very powerful story. And I think each of us, especially those entrepreneurs, we all have our own unique story, like I share you with my son.
We all think that somehow we convince ourselves that we don't fit this perfect mold, that we're outside the industry, and that we didn't go to the right schools or have the right amount of capital to invest, have the right economic background or the right education. And we stay in our comfort zone, and then people will keep you in that comfort zone if you let them. And it takes a leap of faith to go outside. Like when you first decided to launch, there's got to be this voice in the back of your mind going, who be's I to launch a toy company, right?
Yeah, exactly.
A lot of people playing small.
I think there's also society is giving entrepreneur a lot of pressure. There's also a lot of naysayers. Oh, this will never work. You don't have the money. You don't have the education. You just don't know what you're doing. And there's a lot of naysayers.
Or all the toys that could be invented have been invented.
Right.
Like that.
Exactly. Which is not true, by the way.
It's not true. They've been saying that for hundreds of years. In fact, the commissioner of the U.S.
Yeah.
Patent Office in the 1800s,
Yeah.
famous quote by him is just he was suggesting that the patent office shut down because everything that had to be invented was already invented.
Invented. What?
1800s.
That's insane. Yeah. He underestimated the unlimited creativity that we have as a human
Yeah.
being. That's always
Yep.
something new.
And it's
So-
still not stopping. Like we have like the internet was like a huge boom. And just when you think there's as much innovation in the internet, this ChatGPT has
Yeah.
opened the
Now,
world. So I don't think we're certainly not anywhere close to the end of innovation yet. And
100%.
absolutely not in the toy industry for sure. And you know that industry
Sure.
like the back of your hand.
Yeah, and I think that's also some common mistake that the toy entrepreneur or the inventor make when it comes to protecting their creation. I think there's a lot of urban myths about patents. Some people say, "Oh, as long as I created it, I can just file for patent anytime I want," which I don't think is true. And hopefully, we can demystify or bust
Right.
some of those myths today in the interview. So I guess one of the common misconception is there is a timeline on when you can apply for the patent. And I think that's only a year, but if you can educate the audience on
Yes,
exactly
of course.
what the
So,
timeline.
and the law has changed, and that's why there's some confusion. Before 1990, before 2013, US was on what's known as a first to invent system. Because you invented first, you were fine. And how do you prove you invented first? You keep receipts, you keep a notebook, and you document your invention. You get somebody to witness your idea. All
Yeah.
of these things were very useful. But in 2013, the law changed from a first to invent system to a first to file system. Today, the US is on a first to file system. Whoever
Yeah.
filed the application first,
Own the
so
idea.
there's still a major push. You need to move quickly and file the application first. What's confusing is you hear a lot about this, do it within a year.
Yeah,
So-
that's what I heard. That's not true. Okay.
Yes, do it within a year, but that does not mean you can just sit back and take a year. What that means is that if you launch your idea or publicly disclose it or sell it, and you take 366 days to file a patent, you take 1 day more than a year, then you can't, that's it. You cannot publicly disclose your idea and take 1 day more than a year to file for a patent. That doesn't mean you should wait you shouldn't wait at all. As soon as you have it, you should file for the patent right away. But the myth is a lot of people think, oh, I can relax. Let me see if it sells. So they want to test the market. Let me see if there's demand. Let me get a better version. This is the beta version of my product. Let me get a more advanced version. All of those are mistakes. You need to get that patent
I
on the
see.
rough version as soon as you can.
I see. So just to clarify, when does that 1 year start? By the time you list it online, or when
Yeah.
does that start? Okay.
So any kind of public disclosure, you put it on Amazon, you list it online, you put up a website. In fact, post it on TikTok, Instagram.
That
anything-
count as well?
No, anything that's public
Oh,
disclosure
wow. I didn't know that.
or sale. You sell one toy, you sell one, and all of a sudden the year starts. So you have to be really careful not to do that. But I think it goes beyond that. You should not even want to sell until you have it protected. Because if it has potential, then somebody with a lot more resources is going to jump in and start selling the product.
Yeah, but this is also a tricky problem for some of the startup entrepreneur, because I remember when I first started my toy brand back in 2016, I don't have the cash to file for a design and utility patent. It's very
Yeah.
daunting on the cost, and I can barely pay rent when I start a company. I don't have the time and the money to invest into something. Of course, maybe we can also touch about the cost, because there's also two type of patent. When I'm talking to newer toy entrepreneur, they don't understand the two and the implication about each, and why is one is so much more expensive than the other. Maybe we can start out there first, then we can talk more about this dilemma that the entrepreneur also faces.
Yes. So of course.
Right.
So there's two types of patents. One is a design patent. And what the design patent means is that it protects just the look of an idea. And if it's a new toy, and it doesn't work any different than anything else, then it'll protect the look of that toy. Let me illustrate that through the
Yes.
Frisbee is, of course, a patented idea.
Yeah.
Now, this one, for example, I'm going to pull it close. You can see that there's these little lightning bolt type things, right?
Yeah, that's
on
like
this.
okay.
Now,
That's
if those have no function and it's just for beauty, you could file this with a design patent, and that
okay.
protects just the
The
look,
design. Okay, just
the
the
look
look.
of it. So nobody else can create a frisbee that has this particular look,
Look.
but
Okay.
it's a very narrow patent because
Yeah.
instead of having it look like a lightning bolt, they could have it look like, I don't know, a ponytail or something.
Yeah. Yeah.
Oh,
They can just change it slightly to bypass the patent
yeah.
altogether.
So that's the downside of design patents. But as you can tell, it has a design on the back also. But on the
Oh,
other
you
hand, what if this has an actual function? What if it provides a better grip? You could
Okay.
say it's more aerodynamic or has
Okay.
some
Some
useful
kind of
reason
function.
other than just pleasing to the eye. It's
Yeah.
some function. Now you could file a utility patent.
Good
Now, a
patent.
utility patent is that it's useful for a function that it performs, not just for the look.
Yeah.
That's the other type of patent. Now, you asked about cost. In
Yeah.
general, design patents are about a third of the cost of utility patents. So I would say roughly you may be looking at about anywhere from $3,000 to $6,000 for a design patent to protect the look. Now, a utility patent, on the other hand, is generally about $9,000 to $18,000.
Oh, whoa. That's a big range.
But it's also a lot better protection because you get a
Sure.
utility patent and now nobody can create something that performs the same function in pretty much
Yeah.
the same way as your idea. Then you have much broader
Yeah.
protection. A design
Okay.
patent is less expensive, but you might have to file more than one to protect
Yeah.
different variations of your idea. And you might not have to do that.
Okay. Thank you for the explanation. That's very helpful. But going back to the entrepreneur dilemma that I was explaining earlier, instead of putting $18,000 and buy $18,000 worth of product, should I spend 18,000 and work on the patent? But I don't even have the money to put in for the initial production run.
Yeah.
Again,
So
very tricky.
no, that you bring up a
position.
great point. Now, the patent office realized this dilemma back in 1995
Yeah.
because of a utility patent. The most difficult part and time-consuming part, is the claims of the patent. And so I know you're familiar with this, but a lot of your
Yeah.
listeners might not be. The claims are numbered paragraphs at the end of the patent that define how broad your protection is and how close competitors can get to your idea. Usually there's 20 numbered paragraphs. They're very time consuming to draft. They're very tricky and they require a lot of attorney hours to draft. So in
Yeah.
1995, the patent office came up with a new type of patent that
Okay.
doesn't have claims. Thinking was, you know what, for a small inventor, individual inventor, or a small startup, they don't have many times $18,000 to put into this
Right.
idea.
Yeah. Yeah.
So why don't we let them protect it temporarily for 1 year, a type of patent called a provisional patent.
Original content. Yes, I heard of that one before.
So it doesn't have to have claims, so it's lower in cost. Then at the end of the year, if the inventor sees success, he sees interest, there's demand, people are buying the product, investors are interested. Now he knows it's worthwhile to have claims,
Okay. Okay.
and then he follows the rest. So provisional patents many times can be about half the cost of a non-provisional patent. So
Can you do provisional patent for both design and utility as well?
no, unfortunately,
No?
the provisional is only possible for utility patents.
Utility. Okay. Okay.
But those are the expensive ones. So,
Yeah.
I mean,
It's very expensive.
it's all
Yeah.
relative, right? Like for some
Yeah.
inventors, when they're starting up, $3,000 to $6,000 is a big
Still a
expense.
lot. Yes. Yeah.
But that's the design patent. The utility is generally $6,000 to $18,000. Utility patent is more expensive, but the provisional is, I think, a great avenue that lets you temporarily protect your rights for 1 year to the market and see how things are going.
And then at the end of the year, you can decide whether or not to turn it into a regular full-on patent or just you can abandon, I guess.
Can't abandon it. It's unfortunately, if the year goes by, again, this 365 days are critical. If you don't file the non-provisional within 365 days of your provisional or exactly within 1 year, then you've lost all rights to the idea. These dates are super important. That's why this
Yeah.
1 year keeps coming up. If you
Yeah.
file non-provisional in day 366,
Right.
then you waited 1 day too long. And
Yeah.
anybody that has filed in the intervening year, they can trump your rights. they get superior rights to you. So
I
it's very critical if you file your design patent, your provisional patent. If you're working with a law firm, it's their job to keep this date and remind you. You have to file the non-provisional within 1 year.
I see. And what is your take for newer startup or inventor, not just getting patent in US, but also internationally? But it's also going to be more cost, I assume. So
It's
what is
it's
your
more
take on
cost,
that?
but the beauty is that there are international treaties. The most well-known, and probably heard it abbreviated as the PCT treaty. And the PCT stands for Patent Cooperation Treaty. Now,
Yeah.
this is an international treaty signed by, and the number keeps going up. I don't know, 150, 160 countries. Now,
Mhm.
all of these countries have gotten together and they've agreed that if any inventor in any of our countries files an application,
Yes.
all of us have agreed to give him a 1 year grace period to file anywhere else. And as long as they file anywhere else, international application within a year of their local filing, the law will treat all the applications as if they were filed on that first filing date. It's a way to get international protection without spending a single cent on international patents.
But
just
you only
file it
last for a year.
for 1 year. Yeah.
For 1 year. Okay. Okay. After that, what happened after 1 year?
Yeah, within the year, you have to first you file your local application, say in the
Yeah.
United States, local
Yeah.
is into your country. And then within the year, you file a PCT application. So as long as you file that PCT within the year, then you are automatically protected in 160 countries, anybody that's a signatory to this treaty, as if you had filed the international application on the date of your first filing. So it goes all the
Yeah.
way back to your original date.
See.
A beautiful system to where an inventor, it's still a lot of money, but you can have worldwide protection for about $10,000. That's what the application costs. So
I
yes,
see.
it seems like a lot of cost, but $10,000 for 160 countries IP protection, that's really a bargain.
So I have a follow-up question on the country everyone have the most concern with, China. How is PCT going to protect people in China copying your idea?
Yes, one big myth, and since you talk about myths, is that if your market is the US market,
Yeah.
then if all you have is a US patent, the US
Yeah.
patent can be used against imports. You don't have to file necessarily in China to
Okay.
prevent competition in the United States.
Oh,
So
okay.
if
Good
you
to know.
file in the United States, your US patent will protect
Yeah.
you. It prevents anybody from making, using, selling, or importing competing products into the US.
Would
You don't
not
even
want-
necessarily have to have international protection if your concern is just the United States. If you want somebody in China, prevent them from selling it in Canada, then you can either file in Canada or you file for protection in China, and then
See.
you have a Chinese patent as well.
Okay. Got it. So for those of our listener who's really new to this whole patent processes, how long does each patent usually take? Let's just talk about design and utility for a minute here.
Yeah, so there's two dates to keep in mind. The first one is how long does it take patent pending?
Yeah.
What's your patent pending? Then you can sell the idea, you can market, you can speak to investors. There's a lot of things you can do. Generally, for a design patent, you can be patent pending in about 4 to 8 weeks.
Oh, that's pretty fast. Okay.
Yeah. So if you have a product, for example, even right now, you want to launch for the Christmas season, the holiday season, you still have time to file for a design and maybe even a utility. A utility patent takes about 12 weeks. But even 12 weeks to be patent pending is relatively
Quick.
compared to how long it takes to get the patent.
Get
So
a patent.
next. So getting the patent could take, for a design patent, could take up to a year. So that's a long time. Utility patents, usually 2 to 3 years. So 12 weeks doesn't sound that bad.
Yeah.
Patent pending, once you know that it
Takes 2 years
to get it.
I see. And the other thing I think that's also very important, because I also talk to a lot of inventor and also startup toy entrepreneur in the toy and game space. For the new entrepreneur, how do they determine if the idea is actually truly unique and patentable to begin with?
Yeah, so it's a great question. In order to be patentable, the idea has to meet 3 criteria. It has to be novel, which means it has to be a new idea. It has to be useful, which generally useful, basically you can think of it as meaning it has to work. It
Yeah.
can't.
Okay.
So the patent office doesn't look at it and say like this, like a frisbee. What's useful about this? It's a toy. Some
Yeah.
people say toys are not like useful. They're not like machines for creating or doing
Yeah.
work,
Yeah.
but they serve a purpose. They serve a use, enjoyment of that's use. So the
Yeah.
patent office is not too strict on the utility. Like it mostly
Okay.
meet that requirement. The third one is the one that's the hardest. It is non-obvious. The idea has to be non-obvious. To answer that, the most common question is, okay, what's an example of an obvious change?
Yeah.
Typical obvious changes are just changes in color, changes in just shape, like
Yeah.
something the same and you change the shape, or changes in size, like something is super sized or it's super compact.
Yeah.
Those are considered obvious changes. Unless there's some obstacle that makes it harder to make something super small, which is why in the beginning, when hearing aids started getting smaller and smaller, they were patentable because there was an obstacle. There's a challenge to making them small. And it's simple as just, all right, let's just put in a new decimal measurement to make it smaller. It was challenging.
Yeah.
So the size it has some obstacle to make it smaller. That can be non-obvious. Color usually is not changing the color is not a big deal. That's
Yeah.
not to make something a new idea.
Sure.
Again, unless that new color provides some advantage,
I
some
see.
unique advantage. You come up with a color for a car that reflects all heat much better, or it repels insects, or
How
does
about you make it invisible altogether?
the invisibility cloak, like in Harry Potter or something. Now you're talking something patentable, but
Yeah.
otherwise, red, orange, blue, if the color
Yeah.
doesn't do anything, then that's not enough to be protectable.
Got it. Got it. Okay. Thank you for that detailed explanation. And the other thing, because the people I talk to, sometimes they get confused between whole kind of different IP that we need to know as an entrepreneur. That's obviously patent that we spend a lot of time earlier on, but there's also trademark and copyright as well. Can we also touch on the other two and the importance as an
Yeah,
entrepreneur to have all three?
of course. And going back to that story about what my dream of creating the round Rubik's Cube, company that created it, they called it the Impossible. Now, the
That's a
Impossible was a
trademark.
name, it was a brand. And
Okay.
that's what you're talking about. When you talk about
Yes.
trademarks, you want to talk about branding. And it's important to protect the branding because sometimes consumers remember the name and they go into stores looking for the
The
actual name of
name.
the product. I'll give you an example. So this right here, right here. What would you call what is do you know what this is?
A post-it. Post-it
You know,
note?
a
Okay.
post-it note, exactly.
Yeah.
Why did you call it a post-it note? That's a brand name, of course, but this is
Yeah.
no longer the only company that makes these.
Yeah.
If you go into an office supply store and you wanted this, it's very hard to think of another name. People call it a post-it. Sometimes they'll call it a like it's really removable paper
Yeah. It's removable
with
paper.
removable glue, but that's
I actually heard the story behind the inventor of that product is actually a failure. They are supposed to have the glue that is not separable, but the chemical like compound they made actually make it very
yeah.
easy to
So a
separate.
lot of inventions are some would call them failures because they didn't work the way they were designed. But people found out that there's a purpose and there's a benefit to it
Yeah.
not doing. Now, for us lawyers, now everything's going to digital signatures. But I'm 53 years old. I started with real contracts that everybody had to sign with a pen and paper. To tell clients where to sign, when we mailed documents, we would stick post-its on the
Post-it,
document.
yeah.
So with an arrow, so they know where to sign. The benefit of this removable glue is once they sign, you don't rip up the contract. It doesn't damage the ink. It doesn't do anything. You take it off. So
Yeah.
there's a huge benefit to the
Yeah.
type of glue that's used.
So that's an example of the trademark. Can you also give an example of like copyright as well?
Yeah. So copyrights are great generally for creative work that's not an invention and it's not a brand. So you might think, okay, so what's not an invention and not a brand? Oftentimes to sell toys, you have to create videos. The video is copyrighted so that a competitor doesn't copy your sales copy. It can be copyrighted. That's creative expression. So you write an amazing email or an amazing drip campaign for your list that those things are copyrightable and you copyright them. Now, authors are very familiar with copyrights. You write a book that's protect that with a copyright.
That's actually a very controversial topic. I don't know if we have time to dig into it today. How about AI generated copywriting?
Oh, I've done a lot of interviews on that. It's really tricky because under the US Constitution, a copyright author has to be a human. It's
But a human put in the prompt and change
yep. And that's where it gets tricky. Is
Yeah.
the prompt a sufficient amount of creativity to be entitle somebody to a copyright? There's a lot of case law. It's still not settled. In fact, the original cases have to do with, when I say it has to be a human, there was several years ago, a photographer accidentally left their cell phone in a site in the jungle, believe it or not. Monkey picked it up and took a bunch of selfies. Cell phone. Now, those selfies became internet famous. Like they went viral. They were all over the internet. And
Yeah.
the owner of the phone, now people started publishing, doing all kinds of things with that photograph.
Yeah.
Owner of the phone tried to get a copyright for the selfie. And the
Okay.
court refused and said that the author is not the owner of the phone. The author
It's
is
the
the
monkey.
monkey. A monkey is not a human, and therefore a monkey's not entitled to a copyright, and they lost copyright protection. Those cases have now become relevant again. It's proponents saying that AI generated images should not be copyrighted,
Yeah.
meaning that the author is ChatGPT. As an AI, it's software, it's a machine, it's a robot, and it's not a human. So therefore, it should not be protected. Those that are arguing that it should be protected are saying that the software is a tool, and a tool is different than a paintbrush. Like you can't deny somebody to be the author of a painting because they used a brush. The brush is just a
Yeah.
tool.
But the brush is too powerful right now. That's where
That's the problem. That's the problem. The others say that, wait a minute,
right now.
AI is not just a paintbrush. AI is way too powerful of a tool. We've never had a tool this powerful before, so it doesn't powerful of a tool. It doesn't count. After all, photographers use a camera, and the camera is taking the picture, but the difference is the human being is deciding which direction to point, hiding the lighting, the timing. There's a lot of decisions. The difference with AI generated products, whether it's artwork or essays or books, is that the human input is really tiny compared to the creativity that the software produces. It's gonna be years before we have a clear answer on that. And I have a lot of research on this, so we could have a completely separate
It's a very controversial topic for
on
sure. So,
AI generated intellectual property and the protection.
but going back to our conversation earlier, are there any specific strategy that you advise your client for the inventor or the entrepreneur that they can use to monitor and enforce their IP like in an efficient manner? Because how do you know if someone just copy you on different platform, either online or offline? Do you have any tool that you use to monitor all that?
So of course, for images, there's like watermarks. Like a lot of companies will put watermarks into their images. If it is text, like if it's sales copy or whatever, there is plagiarism checking software that will identify when somebody is copying. Unfortunately, for physical products, there isn't a technology solution. The best way most companies find out is that their own customers come back to them and say, hey, it's somewhere else cheaper. And you say, wait a minute, this is not supposed to be anywhere else because I have a patent on it. That's not a high-tech way of finding out. It's very low-tech, but that's the way most toy entrepreneurs find out that the product is being stolen.
Well, at least Amazon's trying to make things a little bit easier for the entrepreneur. There's a tool in Amazon to report violation as well. I don't know, have you deal with any of the brand yourself that's also selling on Amazon to help them to
So that
enforce,
helps
right?
with like trademark infringement. And Amazon's got they have some great ways that without spending a lot of money on legal fees, vendors can try to police their mark. If they see something that is infringing, they can bring it to Amazon's attention without having to hire a lawyer. So it is a great way to protect your intellectual property. And I think Amazon, but there's all kinds of other platforms that offer the same thing. eBay offers the same thing, for example, that Amazon has. Something very similar.
The problem we having encountered with some of our clients that does have IP is when you try to enforce the right with Amazon's team, the entry level people that's in charge doesn't know whether or not it's really infringing or not. I look close enough, but is it really infringing? And we have issue with some of our clients. Oh, have a trademark and no, not trademark. I have a design patent that I designed, and one of our competitor copied the almost identical design. But then the Amazon rep come back and say this is not the same. Something is a little bit different, so it's technically not infringing on your design pattern or something similar to not nature. What would you say in that circumstance? Is that a time to hire someone like you that specialize in it?
Yeah,
Or
100%.
against
So
Amazon?
now the beauty is that most times Amazon takes the position of finding the allegedly infringing product to be infringing, and they write to the other competitor and
Mhm.
threaten to take the site down, down,
Most of the time,
unless
yeah.
they can get a letter from an attorney, a patent attorney, showing that there is no infringement. So a lot of times Amazon is in favor of the plaintiffs or the person that believes their idea is stolen. Amazon just says, okay, we're going to put the burden on the person, the other company that's selling, and they
Yeah.
have to prove that they're not infringing.
Yeah, that aligns with a lot of my experience, but there's also some scenario that Amazon doesn't
Yep.
do that. That's where it get very frustrating. Try to communicate and convince whoever the person that's typing no after the keyboard. Maybe it's AI, I don't know, but that is
Right.
doing it. That doesn't really fully understand the spec or the scope of the patent as in the level that you do as a professional. So as well, winding down in today's interview, the last question I have is, what advice will you give to a brand new, like a startup toy entrepreneur who is just getting started in their product or toy company journey when it comes to all the different kind of IP they should be considering? What is the right time and when is the right time for each different type?
Yeah. So I'll tell you the biggest mistake I've seen toy inventors make is that they think they have to have something super complicated in order to get protection. They don't realize, like I talked about the Post-it note, this is not complicated. This is removable glue on paper. And they generated $1 billion of revenues based on this. Another well-known patent is the sleeve on a cup of coffee. This is just a
That's
cardboard
patent too? Oh, okay.
and it's patented, and the inventors made $1 million a year for 20 years off of this idea. One of the quick examples, this would be the last one, but I think this is important enough. So many toy inventors are like, well, this is nothing. This is so easy. Here's a container where the label, if you look at it, it's upside down, right? So if you store it this way, the human mind is not happy seeing this bottle and this.
Yeah.
So what do? You store it upside down. Now,
Yeah.
the benefit is now when you need ketchup, the ketchup, because of gravity, is already here. But some would look at it and say, are you kidding me? An upside down label? How is that patentable? But you can take 2 or 3 different features and combine them. Like in this case, a nozzle that is non-drip and the fact that the bottle is squeezable and soft. These 3 features combined can provide for a patent. So it goes back to, if you're a toy inventor, don't write off patents because you think your idea is too simple. Like some people think that to get a patent, you have to have a cure for cancer, or you have to have a flux capacitor, going back to the Back to the Future movie. It doesn't. It could be something really simple. That's one big disadvantage. And another thing is, don't overlook your brand. Sometimes the brand is phenomenal. Like this, get the patent on the idea, but also get the name. Post-it is an incredibly powerful name. So we got the name protected as well. And then finally, the third area, don't forget copyrights. If you write an amazing email or you create a great video, copyright it so that your competitors don't steal that.
I see. Thank you so much for a piece of advice. And also the major benefit of having the trademark is you get into Amazon brand registry, which is very important if you want to compete.
100%.
But thank you so much for being on today's podcast. Where can people find you online?
My own trademark is the Patent Professor. So if you type in the Patent Professor, that's our website, thepatentprofessor.com. But type in the Patent Professor on any social media platform, Instagram, Facebook, TikTok, LinkedIn, it doesn't matter. And you'll find us, the Patent Professor. And that's what I was known as in my years of teaching as a professor. And that's how I branded my law firm.
I see. That's a great trademark, by the way. Very memorable, very easy to spell.
Yep. Thank you.
That's important. So for our listeners, thank you again for tuning in to today's episode of Toy Business Unboxed podcast. We hope you have enjoyed the conversation and find it insightful and inspiring. If you like what you have heard, be sure to subscribe to our podcast on your favorite platform so you never miss an episode. We really appreciate your support and would love it if you can leave us a review or share the podcast with your friend and colleague. For more resource, tip, and the latest update in the toys and game industry, visit our website at toy-launch.com. Join the conversation and connect with us on social media using hashtag Toy Business Unboxed. We'd love to hear your feedback and suggestions for future episodes. Until next time, keep innovating, keep creating, and keep bringing joy to toys. This is Jason Shea signing off on the Toy Business Unboxed podcast. I'll see you in the next episode. Thank you, everyone.